Contractors versus the City of Hayden. Matters before the court for oral argument. Jason Risch will argue on behalf of the appellant, and on behalf of the respondent, Christopher Meyer will argue. Martin Hendrickson will appear. Any preliminary matters? Very well. You may proceed, sir.
Clerk, Counsel, my name is Jason Risch, and I am the attorney for North Idaho Building Contractors Association. This association is a trade association of home builders. They are small businessmen and women from North Idaho who strive to keep affordable housing for the citizens of North Idaho. Several are present here in the courtroom today. The respondent in this matter is the City of Hayden, which is a city in North Idaho that had a 2010 census population of 14,560 people. I bring that up because that becomes relevant later in my argument. The dispute that we are here today to discuss is a dispute over an illegal tax, or as the city deems it, a fee. In fact, the city, you will hear it referred to as a capacity replacement fee. I would urge the justices that this is just clever wording, and this type of fee does not exist anywhere in statute. This fee is collected solely to be used for expansion of the sewer system in the city of Hayden. This fee is not used for repair, upkeep, or maintenance of the current system whatsoever. When complete, this fee goes into a fund, and when the dream idea here is that when this fee is fully collected, there will be about $20 million collected, and it will provide infrastructure out into the entire area of impact of the city of Hayden. Welsh Comer, who is the city's expert, and I will get to more on them later, but they themselves deemed this fee, this project, a, quote, ambitious $20 million capital improvement plan. Your Honors, we are here today to argue that if the city wants to be ambitious, it should sell its vision to its voters and to its citizens. It should not be forcing my clients to pay for this ambition through the fee that it has enacted. Justices, normally 30 minutes is satisfactory for me when I'm before this court, but we do have a lot of ground to cover here today, and so I ask your forgiveness if I move very quickly. Quite simply put, the issue before this court is, do Idaho statutes allow cities to charge a fee to fund the city's wish list of capital improvement projects which are exclusively related to expansion of their infrastructure? Our briefing analyzes the statute at issue, and our argument will complement that, and we believe it highlights that the answer to this question is no. Justices, this case is a question of law. The facts are relatively undisputed. I know you hear that a lot, and we all say that. I joke that whenever there's two lawyers in a room, the facts are never undisputed. But for the most part, the facts are not in dispute here. The relevant facts, just to touch on 4 or 5 of them, are first that this fee is used 100% to expand the system's infrastructure. I don't think there's any dispute over that whatsoever. It's also undisputed that this fee was $580 in 2001. It went up to $737 in 2005. In 2006, it rose again to $774. Then on June 7th in 2007, the city raised this fee to $2,280. That's a 195% increase.
And why is that relevant?
Justice, I believe it shows it shows what the city's intending to do with this fee. It shows that they are.
Is there anything in the record that suggests that the prior charges were somehow reflective of actual replacement cost?
There isn't, Your Honor. I use that simply to highlight the egregiousness of the city's overreach into trying to fund their.
Is there anything in the record to indicate that the fee increase is related to the percentage of the cost or the value of the current system?
There isn't, Your Honor, and that's the whole point of our argument, and I'll be pounding on that throughout my argument, Your Honor. As I said, this fee goes into a fund. The fee is intended to raise $20,416,900. The infrastructure that will be built out into the area of impact will serve 37,835 people. That's, again, relating that back to what I stated previously. The current population in 2010 was 14,500. To put this in perspective for me, being local here, the city of Hayden right now is about the size of Kuna. After this is all said and done, if their plan, their vision, they're planning on being the size of Twin Falls. It's also undisputed that the fee, that the Welsh-Comer report was the only basis for the fee. They were the ones that crafted it. Justices, I'm going to touch on the two areas of law here that the lower court focused on in authorizing the fee. The lower court found that the fee was in fact authorized as an equity buy-in fee and a user fee. The equity buy-in fee, it finds its basis in Idaho Code 50-1027 at SEC. It is known as the Revenue Bond Act. The concept of this fee is to allow a new user that comes onto a system to buy into the equity of the system into which they are entering. The fundamental part of this concept is equity. Before you can have equity in something, you have to have built it. It must exist. The equity buy-in fee is for buying into a current system. It is not for funding future expansion of infrastructure. The Idaho Revenue Bond Act, specifically 50-1028, makes it very, very clear that you cannot use an equity buy-in fee as a source of revenue to the city. $20 million to pay for expansion, I argue, is in fact revenue. The equity buy-in fee is refined by a seminal case, something this court has heard several times and has had the opportunity to examine on several occasions. It is the Loomis v. the City of Haley case. It's cited as 119 Idaho 434. It is a 1991 case. This case, the Loomis case, articulated several refinements to the equity buy-in concept. The Loomis case, the City of Haley was actually doing something very similar to what the City of Hayden is doing here, and it's basically had a fee in relation to its sewer system. There are several aspects of Loomis that are very helpful and provide guidance when it comes to equity buy-in fees. The time constraints prohibit me from going into all of them. What I would like to focus on, I think the key language in that case is that case focused on reserves. The citizen that was objecting at that point in time was arguing that the City of Haley could not build up a little reserve account based upon its equity buy-in fee. The part that I'd like to focus on is that reserve and the replacement. The Loomis court found that was okay, that the city could have a little bit of money to have left over as reserves to address the sewer system. In fact, the court gave us a standard of the ordinary and necessary. In fact, it gave us a list of what it would consider acceptable under ordinary and necessary. And I quote, ordinary and necessary would be, and I quote, repair, partial replacement, or reconditioning of existing equipment. That is at page 439. The court went on to state a list of things that would not be acceptable under an equity buy-in fee, and I quote, new construction or purchase of new equipment or facilities. Again, quoted at page 439. That is exactly what the City of Hayden is doing, is they are using all of this fee to go toward new construction, toward new infrastructure. There are several prodigy to the Loomis case that are helpful to the court and to the parties to this case. The most helpful, we believe, is the Viking Construction v. Hayden Lake Irrigation. That is cited as 149 Idaho, 187. It's a 2010 case. I can tell this court that there was quite a bit of disagreement as to what this case stands for. I cite it in my brief. I believe it supports our position. Respondents cite it in their brief, and in fact the lower court relied on it. We are at quite an impasse as to what it was the court was trying to say. We are fortunate and very lucky because it was these 5 justices that we stand before today that decided that case. So I won't spend a lot of time going into it. I know you're familiar with it. The respondents claim that this case is the basis for their fee, that case says that they can charge this fee and use 100% of it for expansion. We argue to the contrary. There is very clear language in that case that states that the fee must be based on the value of the existing system. In fact, if I may be so bold as to read the court's own language back to it, Viking is quoted as, however, for the connection fee to be an equity buy-in, it must be based upon some calculation designed to determine the value of that portion of the system that the new user will be utilizing. If there is no attempt to calculate in some manner that value, then the connection fee is not an equity buy-in, regardless of its label. This is exactly what we're arguing here before the court today.
Well, what is the meaning of the word new system that it is buying into? That doesn't seem to indicate an old existing system, does it?
I'm sorry, Justice, I'm not following it
I
says
thought-
new user.
New user, I'm sorry.
Yes, Justice,
Okay.
and so that would be,
I misheard you. Thank you.
I'm sorry, perhaps I misread it.
No.
So that's our argument, though, is that it has to be related to a current system. You can't be buying equity into a system that has not been created yet. And the Viking case said that you have to focus on looking at the report. You have to look at where this fee came from. And so I'd like to do that now. In Viking, there was some other, there was a lot of deposition testimony to find out how the district came to its fee. In this particular case, in Viking, they didn't have the accountants or the engineers. In this case, they did. They did hire an engineering firm. It was actually Welsh Comer was an engineering survey firm. They were employed by the city in March of 2006. The city went to Welsh Comer, and it basically provided Welsh Comer with a wish list. And it said, look, we want to build the sewer system out into our area of impact. We would like your help in creating a fee that will let us do that. So the experts, the Welsh Comer engineers, went out and they set about basically creating this imaginary system that the city wanted. They valued that system. They came up with a number, $20,416,900. Then, in order to figure out how to pay for it, they simply took that number and they divided it by the amount of people that would be served through this system. And that's how we came up with the $2,200 fee that we see here today. What's missing from this analysis? What's missing is exactly what this court said you need to do in Viking, which is pay attention to the current system you have. Provide us a value of the current system, and then that's where you get your equity from. There is no reference to the current system in the way that Welsh Comer obtained their value. And what's important is to keep in mind that this fee is being charged to the users of the current system. This isn't when this is created that eventually they're going to charge this fee. They're charging it here today to the users of the current system. Going back to the Viking case, the quote that I said before was, you have to focus on the portion of the system the new user will be utilizing. I asked this court, what part of an unbuilt system will the user be utilizing? The answer is no.
The new user doesn't have to wait till it's built before it can dispose of sewage.
Pardon me, Justice.
I assume the new user does not have to wait until the extension is built before it can dispose of his sewage.
Yeah,
doesn't accumulate it in the house until...
No, it does not. No, yes. Justices, there is some lip service paid to the current system in the Welsh Comer report. And by the way, I should note the Welsh Comer report is the entire augmented record. We had some problems getting it before this court, getting it out of the lower court. So counsel and I stipulated that augmented record is the entire report. And I would refer the justices to that. So as I said,
when you say user, are you talking about the contractors or the property owners?
well, Justice, this fee is charged to the to when the building permit is pulled. So this is something that's charged to the contractors.
Unless a user, somebody buys a lot, hires somebody to build a house on it for them.
Right, it's part of the building permit. It has to be paid for with all the other fees that the city of Hayden has.
I was curious because, you know, every time you have a case involving a tax, there's a question of standing. Where does the incidence of the tax fall? And I guess, does the incidence of the tax fall on the contractor or upon the property owner?
That's a good question, Justice. In fact, there are, not only is the association a member or a plaintiff in this case, but also we have an individual contractor that came forward and lent his name for this case so that we would have standing. And the argument is that this is something that there isn't necessarily a difference between a property owner and a contractor. Contractors can buy lots. They're the ones that would own it. Regardless, the the fee has to be paid at the time you pull the building permit. The Justices, so if I may go back to analyzing the equity buy-in, the report simply doesn't provide the proper analysis. The correct way to do an equity buy-in would be to focus on the current system, focus on the value of that system, and that is just completely lacking in the report. In fact, the report is devoid of that analysis. This fee is quite simply raising revenue, which is, we know, is prohibited by the Act that authorizes it. It is also prohibited by the Loomis and Viking cases. Justices, now moving on to the user fee analysis, which is another fee that the lower court focused on and found authority for. The user fee is provided in Idaho Code 63-1311. In fact, the enabling statute states, notwithstanding any other provision of law, the governing board of any taxing district may impose and cause to be collected fees for those services provided by that which would otherwise be funded by property tax. The fees collected pursuant to this section shall be reasonably related to, but shall not exceed the actual cost of the service being rendered. And that is paren 1 of that statute. There is a very well-developed body of case law on user fees. They've been used by cities for quite some time, and this court, I know, has reviewed them ad nauseum. Suffice it to say, the test that comes out of that body of case law is when this court analyzes this type of fee as to whether it's a fee or an illegal tax, we look at the services that are being rendered. Is the fee tied to the services that are being rendered? There was a case, the Brewster v. City of Pocatello was a street fee case. My time does not allow me to go into that on the analysis, but it provides guidance to this court. That was a fee that was struck down because there was no relationship. I think what's important to note here is that Hayden actually does have a user fee. It's an addition and different than what we're fighting over here today. They call this the bi-monthly fee. And this fee is used to take care of the current system. It provides for the maintenance and the upkeep and the operation of the current system. We don't object to that fee. That fee is, in fact, a user fee. The citizens directly benefit from using the current system. The citizens pay for the collector pipes, the mains, the lift stations, and everything related to the current system. This expansion fee is not a user fee. I refer you back to the analysis I just went through about how Hayden established this fee, that there was no consideration to the current system. And really, if you just kind of look at it from a general aspect, the fee has to be related back to the service that's being provided. A system that isn't built yet can't possibly provide a service. There is nobody getting service from this system. There were two cases that were focused on that the lower court focused on, and I'd like to touch just briefly on each one of those. They are the Albert v. the Boise Water case, 1990, and Kootenai Property Owners v. Kootenai County, which is a 1989 case. The key to any analysis of a fee, where we start, where this court always starts, is an analysis of the enacting statute. That's where you have to go. That's where it starts. The enacting statutes in those two cases are completely different than what we're talking about here today. Albert case was analyzing franchise law. The Kootenai Property Owners case was analyzing landfill statute. That statute specifically said you can use your fee to buy land for future expansion, for a future dump. And so those two cases simply are not applicable. And in fact, that's how the court allowed those fees to stand, was it went back and it looked at the enabling statutes. So with respect to the lower court, we don't think that those cases are applicable here.
If we agree with you, what is the appropriate remedy? I know you want us to just simply say it's unauthorized, but wouldn't an alternative be to remand for an evaluation of the cost of tying into the replacement cost of tying into the existing system, whether that be a historical cost or a replacement cost?
Justice, our request would be that this fee be ruled to be an illegal tax, which would make it impermissible.
I recognize that, but why don't we send it back, if we accept your premise, for an evaluation of the replacement cost of the existing system and figure out what the proportionate cost value of that tie-in would be?
Justice, that is certainly a position that this court can take. I would argue that that is a completely different fee. It's a completely different analysis, and you'd have to throw everything out and start all over again, which they're entitled to do at any point in time if they want to.
But the complaint is about the amount of the fee that is presently being charged and the assertion that that represents a tax. It seems to me that it involves an underlying factual inquiry, setting aside the methodology that they employed as to the actual replacement cost.
It would be, Justice, but again, I think that's a completely different analysis that you go through. And their report didn't focus at all on the current system, and so to send it back and say no, you have to do this over again, I think is not the correct way to analyze this. I think the way you analyze this is you throw out the fee and say you screwed up. This is no good. It's an illegal tax. If you want to do it, go ahead and we'll try it again, but not necessarily through this system. The burden would then be on us to fight through that system as they do it, and that's just not the proper procedure.
Would you be here if the fee had been set at $774 and kept at that rate instead of increasing to $2,280?
Justices, I'm not sure I can answer that question. That's a question that my clients would have to, I mean, at what point in time does the fee become so onerous, the illegal tax becomes so onerous that you have to bring it to court? I argue that, yes, we would be here because the fee, the way they based it, no matter the amount, no matter what you come up with, it's an illegal tax because of the way they enacted the fee.
Well, it looks like it was unchallenged, It seems like the amount was what precipitated the challenge, and if it was illegal in the initiation, it probably would have been best to challenge it at that time.
I can't speak to what was happening up at Hayden at that time, but as we all know, there's economic impacts that come into every sort of litigation. There's a lot of things that happen that should be challenged that never reach this court scrutiny just because of the cost. Justices, I want to reserve some time for my rebuttal because I know we've got some pretty thick arguments to go through. I would merely touch on one more fee. That's the impact fee, and I will just summarize that. The arguments I was going to make in that are that the impact fees are the way this should be done. They are out there. They are a mechanism for growth, paying for growth. That is the proper process. There's very important...
That was one of the financing options considered in the report and rejected because they didn't want to go through that process.
Exactly. And so Justice, to stand here and say that this fee should stand, you're going to have to go through a lot of gyrations and a lot of different things in order to justify this fee. There's no reason for it. That's what the impact fee statute's there for. But the impact fee, it's important to note, creates a bunch of checks and balances so that this type of abuse can't happen. It makes sure that the growth is only paying for the growth that's actually necessary, the part of the area of impact that will be affected. To say that the entire area of impact is going to be built out and that you have to pay for it here today is not appropriate. And so you have to ask, why didn't the city go through that process? It's because it wouldn't have stood up to the scrutiny. By the way, the city of Hayden does have an impact fee. It's a $5,447 fee in addition to this one as well. With that, Justices, I will reserve the rest of my time. Thank you.
Thank you. On behalf of the respondent.
Mr. Chief Justice, members of the court, counsel, may it please the court, I'm Chris Meyer, Givens personally, here on behalf of the city of Hayden. With me is Martin Hendrickson at council table. When municipalities cut corners or leverage their regulatory authority to obtain financial gain, courts have a tendency to come down pretty hard on. That has happened in this court on a number of occasions. The concurring opinion in the Black versus Young case really hammered on the city of Ketchum for asking for something in exchange for vacating an alley. This court was not impressed with the city of Pocatello, which took an end run around voter rejection of increasing property taxes. The most recent case probably takes the prize, the Old Cutters case, in which the federal court hammered the city of Haley for imposing an ever-increasing annexation fee, finally topping out at over $3 million. Judge Lodge, in that case, by the way, drew a sharp contrast to a case that this court recently decided, the Buckskin case, where the county imposed a fee that was, in fact, tailored to the cost of the new infrastructure. Well, if the city of Haley is the poster child for governmental overreaching, I would suggest that the city of Hayden deserves a commendation for frugal, cautious, careful governmental policies. But frankly, it's something of a mystery to me as to why we're here. The city did exactly what this court instructed in the Viking case. It hired professionals to go out, meticulously quantify the cost of replacing the infrastructure that would be consumed.
This isn't replacing the infrastructure, it's extending it.
Well, it appears that we are focusing on that word replacement. And, Your Honor, I think that's a good place to be.
Well, but does the city's current system extend to its entire area of city impact?
Well, it doesn't today, Your Honor.
Right.
What we have today is a situation where the city has some excess capacity. It doesn't need to enact a cap fee at all. It could just sit back and allow that excess capacity to be used up until there isn't any, and then impose a moratorium on new building permits and let everybody scramble to figure out how to fund some extension of the system. But instead, the city adopted the more frugal approach, the one that was encouraged by the legislature in 1980 with its adoption of 63-1311, and also was authorized by the even earlier enactment of the Bond Act. Now, this court said, Justice Eisman, it was you who wrote the opinion in the Viking case. So obviously,
Yeah, but you're confusing the difference between the power to spend and the power to tax. And the Viking case didn't say you can tax to extend the system. The issue in the Viking case was whether or not the fee imposed was calculated based upon the value or a percentage value of the current system. And we said you could either do that by replacement cost or by historic cost. It was up to the city as far as valuing the current system. But in that case, they just took a value that other cities or entities had used and said, we'll use the same one they do.
that's quite right, Your Honor, and that is
I hope so, it's right, because I wrote the opinion, yeah.
Yes, and we agree
And
with
so that
that.
wasn't done in this case.
Yes, Your Honor.
Where did they value the current system?
Your Honor, that is precisely what the city of Hayden did.
Where is the value of the current system in the report?
Your Honor, the way that you said in the Viking case, Your Honor, that you can base that value on replacement cost.
Of the current system, not on extension.
Right. And what is the logical way to do that? I mean, one could say, oh, well, what if we dug it up and put it back in? What would that cost today? That would be one way.
You're not replacing the current system under what's happened in Hayden. They're extending the current system to include areas that are not covered by it.
Yes, precisely what was done in the Viking case as
No,
well.
it wasn't what was done in the Viking case. That was not the issue in the Viking case. The issue in the Viking case is whether the fee that they were charging was based upon the value of a pro rata value of the current system. And it wasn't.
Your Honor, in the Viking case, this court, in your opinion, recognized that the Bond Act could be used to extend the system.
No. The Bond Act can be used, another subsection of it can be used. What they were saying is that the fees, if they calculated the fees properly, they couldn't use it to do any extension or construction. We said, no, doesn't prohibit that, but you're confusing the difference between being able to act and being able to tax. The fact that the city can do something doesn't mean it can raise a tax to do whatever it costs to do that.
Your Honor, there are two provisions of the Bond Act that this court found were applicable in the Viking case. It's 50-1030 subsection A and subsection F. Now, there is another section, I can't think of the number off the top of my head, that you addressed in your opinion, and you said that was not applicable because that other section, and that was another section dealing with a particular type of reserve, is applicable only if the city issues bonds, which of course is not the basis of this case. But subsections both A and F are applicable. That was the decision of this court. And subsection A specifically includes the right to better or extend works.
Yeah, but A is not does not grant the authority to raise money.
But, Your Honor, you said that it did in the Viking case.
You're misreading it. I mean, I'm not going to, you know, we're never amazed at how people can misread what we say, but that's just the nature of the job.
Well, Your Honor, let's go back to the question that you raised at the outset, which is we all seem to agree that it is appropriate for a city to value the cost of the cap fee based on the replacement value
System.
of the current system. And in particular, in the Viking case, it said it can be the replacement value of the excess capacity.
No, we said it's the current system.
Your Honor, it says, the case says, and I quote, thus, this section, referring to the Bond Act, permitted the irrigation district to charge new users of the domestic water system a connection fee that included an amount equal to the value of that portion of the system capacity that the new user will utilize.
Right.
Now, the system capacity that the new user will utilize is obviously excess capacity. Otherwise, they couldn't be utilizing it.
Well, there's excess water. They're not using all the water.
It's not water, it's sewage, Your Honor. It's empty pipes, Your Honor, that are being utilized.
Are there empty pipes going throughout the area of city impact in Hayden now?
Not throughout. No, that's the whole purpose of having a cap fee, to allow new development when the city begins to move out gradually, incrementally, efficiently.
Yeah, that's basically an impact fee.
Well, that is an impact fee, Your Honor. Right. But this court has
But you
not.
didn't follow the impact fee statute.
No, Your Honor, and nor did Viking.
Well, Viking. Well, I'm not going to debate your misreading of Viking. That's fine. That had nothing to do with an impact fee. It was, the only issue was whether the fee that was supposed to be based upon a percentage or provider share of the value of the current system was based on that. And they didn't do any investigation into the value of the current system. Same was here. There's no investigation in the report, in the Comer report, as to the value of the current system. If there is, why don't you show me where it is? Tell me which page it's on.
Well, Your Honor, it is contained throughout this report.
No, tell me the page where it values the current system, not the cost of construction to extend the system, but the value of the current system. Show me where that is.
Your Honor, the city of Hayden has been very forthright throughout this proceeding.
Well, you can't do that. Is that right? You can't show me where the value of the current system is in that report?
It was not based on the pipes that are in the ground today. It was based on the cost of replacing the infrastructure. The way that you replace that.
Are you only replacing pipes that are in the ground today?
No, Your Honor. I'm not beating around the bush here. I'm trying to be as clear as I possibly can with this court. The approach that the city of Hayden adopted was to figure the value of the existing excess capacity by saying, what are we going to do? If we're going to build the next piece, what is that piece going to cost? There isn't any point in going back and having some conjecture over what it would cost to dig something up that's already there and put it back in the ground. it's much more logical to have the fee be based on, okay, what's the next piece of pipe going to cost? There's no reason that the two would be any different, by the way. I mean, why would it cost any more to put in the new piece of pipe to the next subdivision than it would to dig out the piece of pipe that's already there and replace that? Let's be logical about this, Your Honors. What the city of Hayden did was the most fiscally responsible thing that it could possibly do. This court has instructed over and over and over again, cities, in order to avoid falling into an improper, illegal tax, must gauge what the fees that they charge based on the actual cost of the thing that they're doing. If a developer comes to town and says, I want to use the empty pipes or the excess capacity, maybe it's not empty, but it's only half full. I want to use the excess capacity in the pipe that's already there, then how do we figure out what that excess capacity is worth? What is the replacement value?
When did this fee take effect?
When does it take effect?
When did it take effect?
Well, it was 2006, Your Honor.
Okay. I mean, okay, guys, the attachment to the affidavit said, was that just an increase that took effect August 1st, 2010?
I think that is correct, Your Honor.
Okay.
And presumably there will be additional adjustments.
So what you're saying is that, let's say 2 days before the fee took effect, somebody connected because they wanted to build a house on an existing lot in the city. And 2 days after it took effect, somebody else wanted to connect, and suddenly the cost of service for the second person was $1,500 more than the cost to provide sewer service to the first person.
That would be correct, Your Honor.
And so what would make that an increased cost to provide service?
Well,
I mean, they're connecting to the same sewer.
Charged.
They're connecting to the same sewer system.
The earlier users were undercharged. I mean, it's some...
Where in the record does it say that? Where in the record does it value the existing system and say the earlier users were not paying a proportionate share of the cost of buy-in, equity buy-in?
Well, I think that is apparent, Your
No,
Honor.
where? Show me in the report where it says that.
Well, the whole purpose of the report, Your Honor, is to calculate the...
No, can you show me in the report where it says that, where there's an equity buy-in, and this is the cost to, the prior servers were underpaying when they connected for that equity buy-in?
Well, I cannot do that, Your Honor, while I'm standing here today. But there was no smoke and mirrors, Your Honor. The city was forthright in what it was doing. The earlier calculations were not aimed at figuring the replacement cost. It was the Welsh-Comer report that was the first time that the city did what this court instructed it could do in the Viking case, which is to value the cap fee based on the replacement cost of the existing...
Where in the Comer report does it say they're only working on the existing system?
It says it is valuing the replacement value of the excess capacity. The city has...
Where does it say they're only valuing what it would cost to replace the existing system?
Your Honor, the way that they went about valuing the replacement cost was to look at the cost of putting in the next piece of pipe or the next pump station.
What it would cost to extend the system to the entire area of city
Precisely,
impact.
Your Honor. And
that's not the existing system.
My question to you and the rest of this court is, what is wrong with that?
It doesn't follow the statute. I guess that's what's wrong with it.
Excuse me, Your Honor?
It doesn't follow the statute. I guess that's what's wrong with it. They could do impact fees if they wanted to and do it that way.
Your Honor, this court has never said that IDIFA, the Idaho Development Impact Fee Act, is the exclusive means of imposing impact fees. If that was the case, the Buckskin case would have come out differently.
We're not saying it's
They made the same argument in Buckskin, and Justice Jim Jones wrote that IDIFA was not the only means of achieving that. There are multiple statutes that are available, and we've identified two of them that are very clear. I mean, for goodness sakes, the Bond Act says, and this court said in its decision that you can, that it authorizes extension and betterment of the system. And then it says that,
But it doesn't, we didn't say in that decision that you can charge a fee based upon the cost of doing so.
you did say this, Your Honor, and I quote from Viking at page 197. The statute cannot be read as only permitting irrigation districts that did issue bonds under the Act to provide a reserve for improvements to their system. Now,
The Viking case, the Loomis case, none of the cases have said that the equity buy-in can include the cost of extending the system to future users.
Your Honor, what would the difference be if you, as Justice Horton said, if the court remands and says, go back, instead of figuring out the cost of putting in the next pipe, figure out the cost of replacing the pipe that's already in the ground? What would the purpose of that be? It would be...
Complied with the law is
It
one
would be
purpose
the
it might be.
same number, Your Honor.
No, it wouldn't.
Well, Your Honor, if there's a difference, the responsible thing to
I
do...
assume if it was the same number, you would have calculated it based upon that.
My question, frankly, was prompted by this. Our holding in Viking was that equity buy-in is defined of the value of that portion of the system capacity that the new user will utilize at that point in time, not a future capacity, but the existing system that the user is tying into, which raises the question, is this a question of fact as to what the value of the existing system is, assuming we disagree with your interpretation of what we said in Viking, or is this simply a question of methodology, toss the whole system because of an improper methodology?
Well, I would suggest that that if you were to agree that there was something wrong, you certainly ought to remand and have an evaluation of what the difference would be between the two methodologies.
It's only a tax if it exceeds the value of the pro rata value of the existing system, correct?
Exactly, Your Honor. And it seems to me that there's no reason, though, to be so cautious as Justice Eisman clearly is in defining the term replacement cost. I mean, if I'm buying into a country club and there's some excess capacity on the golf course, and the country club says, well, these new users, they're going to use it up, we're going to have to add another 9 holes. What's the replacement value for the holes, the excess capacity on the golf course that I'm using up? Well, isn't the most logical way of figuring out the replacement cost, what's the next 9 holes going to be to replace the 9 holes that you're using up? That's what the city did here. That's the logical way. I mean, any economist would tell you that's the most effective, natural meaning of the term replacement cost. What does it cost to go out and do it, add on the next piece to replace the piece that you consumed? If somebody buys some inventory from a company, they buy some bottles of Coca-Cola, and they say, well, what's the replacement value of that? Well, what's it going to cost to make some more Coca-Cola? That's a natural reading of the term replacement cost. And there isn't any particular reason to think that it would be higher or lower than the last Coca-Cola that was made, or the earlier 9 holes of the golf course. It's just the logical way of figuring out the cost.
Might be a little different to say replace the current system that serves 5,000 people is not going to be the same as the cost of extending it, increasing it like about 160% to serve a much greater number of people.
Well, Your Honor, I see no reason to think that the cost of replacing the existing system...
Well, show me in the record where it says that. I know you have no reason to believe certain things, but show me in the record where it says that, what the cost of replacing the current system is.
I don't believe it's in the record, Your Honor, and I don't think it needs to be in the record, because we have too narrow a view of what replacement cost means. And I guess that's what this whole case boils down to, isn't it? What does replacement cost mean? That's what it comes down to. And if you tell me that if there's excess capacity, the city cannot say, well, what's it going to cost to build the next increment of excess capacity and call that replacement cost, well, then I guess the city's made a mistake.
I agree.
But isn't there a time for this court to say what makes sense here?
Well, you could get an impact fee and do it that way. The legislature's provided for that.
There are reasons why the impact fee was not effective here. And frankly, Your Honor, that has not been an issue in this case. And this court has never said that an impact fee is the only way that a local government can impose costs on a developer. If there's some other statute that works, the local government ought to be allowed to utilize that other statute. There are two other statutes that work unless the court adopts what I view as a cramped reading of the term replacement value, a reading that the district court certainly found unnecessary. And I mean, it seems to me the message that has come through 20, 30 years of this court's decision to local governments is, by golly, make sure you don't just hold your finger up in the air and say, gosh, how much do you think we can get away with for charging this thing? Instead, figure out what the thing costs. That is exactly what the city of Hayden did here. I mean, your decision sent messages all across this state. You are sitting in a very important place, and the message that you have been sending to cities and counties is to get your act together and don't overcharge. Figure out what things actually cost and don't charge a penny more. That is what the city of Hayden did with this Welsh-Comer report. And now I hear, oh, that isn't what we meant by replacement value. Well, for goodness sake, that is the only, at least that is a logical or permissible reading of the term replacement value of the existing excess capacity of the system. Now, and can't we get to the same place under 63-1311? I mean, that statute clearly provided a mechanism for municipalities and counties to move away from increasing property taxes, and said, if there's something that you're authorized to do by increasing property taxes, you can do it by a user fee. The user fee, of course, has to be not a penny more than the cost of the thing that you're providing. That's a clear limitation, but we want you to get away.
But if somebody connected a day before this statute took effect and connected a day afterwards, how would the cost for the second connection have been? The cost of providing sewage system service for the second one suddenly have jumped in cost? Well, the actual cost.
It's very simple, Your Honor.
No.
The first property owner got off easy.
Where in the record does it say that?
Your Honor.
Where in the record does it say that?
If you read.
I've read it. Where in the record is that calculated?
Your Honor, I think I've answered your question.
Yeah, it's not there. That's what the answer is.
The answer, Your Honor, is that the city calculated the cost of building the next increment that will be available to the next user, to the next developer. The whole idea is always to stay a step ahead. That's the responsible thing for local governments to do. That's what the
But
legislature...
what you're saying is there's no additional cost to the person who connected the day after, no additional actual cost to provide the service to the person who connected the day after the ordinance went into effect, but in the future there would be additional costs.
I'm not sure if I'm tracking you, Your Honor. The impact fee is designed to quantify as precisely as possible the value of replacing the portion of the infrastructure that will be consumed by the new user, and then to build the next increment, the same amount more. Now, if there was some user that came on board...
So you're saying this is an
in
impact
place,
fee? You're saying this is an impact fee?
Your Honor, it doesn't matter what you call it.
Why are you calling it an impact fee?
You can call it an impact fee.
I'm asking you if you're calling it an impact fee.
Well, I'm
You
not
seemed-
calling it an
You were
impact
using
fee.
it as an example, an impact fee, so are you saying this is an impact fee?
Your Honor, it was an impact fee in the same sense that the fee charged by Valley County and Buckskin was an impact fee, in which this court upheld. And this court said that it is not necessary for that fee to have been implemented under IDIFA. In the same way, it is not necessary for the city of Hayden to have enacted an IDIFA-compliant ordinance. The legislature encouraged municipalities to move toward user fees in 1980. This court in the Brewster case said yes, but you can only do that if you don't overcharge for the thing. That was codified in 1988. And now that provision of 63-1311 contains a sentence saying that it must be limited to the actual cost of the thing that's being provided. That is exactly what the city of Hayden has done here. Obviously, you and I fundamentally disagree, Justice Eisman, as we have on some other matters recently.
I know. We're coming from different worldviews.
Apparently so. I'll tell you what my worldview is. My worldview is that this court has given clear instructions, which is that cities need to mind their pennies and they must not overcharge for things.
I'll tell you my worldview is follow the law.
Your Honor, so is mine. We do not have different worldviews about that. And that is...
I'm not willing to agree to that, but I'll assume.
Well, Your Honor, I take some offense, frankly, at you suggesting that I have a different view about following the law.
Okay.
That troubles me. That troubles me because I have counseled cities and county governments all over this state. And the first thing I always say is follow the law, be upfront, be honest, do the right thing. And that is what the city of Hayden has done in this case. And for the city of Hayden to be told, the city of Hayden that said, we don't want to cut corners in the same way that other cities have done. We want to figure out exactly what this thing is going to cost and charge exactly that, and they will continue to update that fee from time to time to make sure that it's always trued up. To say, no, that's not good enough is a disappointment. Your Honor, I have nothing further.
Thank you. How much time does the appellant have?
Yeah, 8 minutes.
Sir?
Justices, I appreciate the spirit exchange that just transpired, and I recognize it for what it is. We've stripped this issue to the bone. I think we see very clearly what it is that the problem the city has with this fee and how this fee cannot be justified under the statutes that it is trying to justify it under, or under the limits of the Viking case and their prodigy. So I will touch just briefly on some of the other issues that I think that are very, very important in the brief. Then I will be done. In the briefing in this case, there was a section by the respondents where they actually advocated that the state of Idaho be transferred from a Dillon's Rule state to a home rule state. I can't articulate to the court what I was first thinking when I read that, but what I was second thinking was, you've got to be kidding me. This argument was first of all, my initial instinct was this is a brand new argument. We'd never seen it before this briefing. And then I remembered actually reading their brief before, and it's not just that this is a new argument they're bringing forward, it's actually contrary to what they told the lower judge. And I will quote from counsel's own brief. This is counsel's own statement. The law on this subject is simple. Idaho cities are not home rule cities with respect to raising revenues, so they must have authorization for any tax. Again, the counsel went on. Idaho follows Dillon's rule under which the powers of local governments are limited to those granted, and it goes on and on and on. So it's not just that it's a new argument, which this court should rebuff, because as this court knows, it does not hear new arguments upon appeal. In fact, this court's own language is, it is axiomatic that you do not do that. But, it's kind of an estoppel situation. If you argue one thing below the lower court, you can't come back and argue something different to this court. This is the concept that's based upon fairness, not only to counsel, but also to the lower court and to the judges there. But then after all that sort of settled down, I thought, well, let's do some research on this. And it turns out that there's just no basis for this argument. There is well-established, well-defined rule in Idaho that is, it's over 100 years of jurisprudence, and there is a deep breadth of cases. And I won't waste the court's time arguing the issue. All I will say is the final thing that I settled on is why. Why would you make this argument? Why would you risk offending an axiomatic rule of this court that you can't bring new arguments forward? Why would you argue in the face of 100 years of jurisprudence to turn Idaho into a home rule state, which is a watershed change in the way we do business here in Idaho? The only answer I can come up with as to why you would make that argument is because the other ones don't work. And as we've seen here, it doesn't fit under any statutory authorization, and therefore you have to go back to, well, okay, we don't need statutory authorization, just give us the power to do what we want.
Isn't another explanation just good lawyering, recognizing the possibility that you might not be persuasive on one issue rather than conceding the absence of the merits of what you believe to be your strongest position?
Justice, I think that is also a fair characterization, although one would argue that good lawyering should have happened down at the lower court as well. Justices, I want to touch on the attorney's fees arguments. There was a cross appeal in that the respondents challenged the lower court's denial of attorney's fees. They moved the court for attorney's fees after the case was over. This court is very familiar with the standards upon which they're moving. It's a frivolous standard, which means that we had to have brought our case without reasonable basis in fact or law. This court sees this time and time again. I won't spend a lot of time on it. And I would highlight that the appellate standard is you have to find that the lower court abused its discretion, which is one of the highest standards we have. The one thing I will take a moment just to touch on in regards to the attorney's fees is my argument about the prevailing party that they assert in their brief. I don't think they're entitled to the attorney's fees under the standards they've cited, but I really don't think they're entitled to the attorney's fees under the prevailing party element. I'd like to
back up to the abuse of discretion standard you just talked about.
Yes, Your Honor.
You recognize the degree of deference that we extend to folks that are exercising their discretion. In Viking, we indicated that the irrigation district in that instance had discretion to decide the methodology that it was going to employ to evaluate replacement cost. Why isn't the proportionate cost of extension of the system a reasonable method of evaluating replacement cost?
Your Honor, because of what it was based on. You have to start with the current system. And I heard the arguments of, well, what's a pipe going to cost if you just put in another pipe down? The problem is that when you give a wish list to service your entire area of impact, you create a tremendous $20 million fee. That's what's different than what the current system is. The problem is, and if you want to make it a very clear example, sewer flows downhill. It has to. If you have an area that's being served at the top of a hill, your treatment station's in the middle of the hill, and then you want to expand down below that treatment station, the cost is going to be tremendous to get the sewage up to that treatment station. So you can't. They're apples and oranges. Getting back to the attorney's fees argument, if I may, Justices, the prevailing party, you have to be the prevailing party in order to get attorney's fees. It's a threshold issue. There were two parts of this case. One was the law that we've been arguing here. About the foundation for the fee. But the second part about it was how the city was actually spending this. So they were calling it one thing, and then they weren't, in which we disagreed with. They didn't have the authority to collect the money under that. but they weren't even spending it appropriately. That was the second part of our case, was even if you are doing this according to law, which we don't think you are, you're not even spending it the way that you say you're going to spend it. And that was the second part of this case. After motion for summary judgment was settled, we spent some time analyzing those accounts. We sat down with counsel. Both parties came to an agreement. We found $555,986 that were spent from this fund inappropriately. We also happened to find out that there was $760,000 misspent from the maintenance and operation fund, the other fund that I was talking about. So we came to an agreement that if the city would fix these problems, where we're spending without paying attention where it was spending from, we would be happy in that regard, and that second sort of part of our case would be met, and there was no reason to litigate that. We reached a stipulation on it. We entered that stipulation. Counsel for the city has called those minor accounting errors. And essentially the law, and they want to use the offset, the net change. That's an argument saying, yeah, you caught us being negligent with this fund, but it's okay because we were more negligent with another fund, and so it's all right because we screwed it all up and the net change was very, very small. It's an absurd argument. They were not a prevailing party. It was something that we sat down and we worked out through stipulation. And so, Your Honor, that's the last I have to say about the prevailing party. I would also raise objection to the amount of attorney's fees. The fact that this case lasted for 358 days and their attorney's fees of $221,546, it amounts to $620 a day, every day this case was pending. It's not reasonable. It's ridiculous, and we think that even if they were entitled to fees, that it shouldn't be anywhere near that amount. With that, I would stand for any questions from the court.
There are none. Thank you. Matters now in advisement will render decision.